reverb now. Welcome to a webinar on lifetime wealth planning and creating a tax efficient estate, presented by both WTT Group and Britton Time Solicitors, who we are very proud to have teamed up with to offer this new service to both clients that are currently with us and any potential clients in the future. I'd like to introduce Elisabeth Squires from Britton Time, who will be co-presenting this and, to be perfectly honest, doing the bulk of the presentation, as this is her expertise. Hopefully Elisabeth can hear us.
Yep, coming through loud and clear. Lovely to be here. Thanks for hosting us, Tom.
Brilliant, great stuff. So first, just a little bit about WTT. For those that are not aware of the WTT Group, we are a group of tax and legal and wealth professionals who service what we consider to be the mainly neglected market of the contractor. We have a core client base of contractors and entrepreneurs who are either running their own business or looking to expand business, or perhaps taking on some other role, either permanent, after being in the contracting world. We're guided by a principle of being open. We'd like to provide a very clear view of the contractor's position, and of course, like any professional should, we operate with integrity. And I'm sure when Elisabeth talks a little bit about Britton Time, you'll see why we have partnered with them. To move on to the webinar, I will hand over to Elisabeth. We do have everyone on mute, but we do have a question panel. Please feel free at any time to type a question. I will pick it up and I will, at some suitable point, ask Elisabeth to give her expert view on that question. We will provide contact details at the end, so if there's anything that you don't particularly want to air in public, or it's quite an in-depth question, please do contact us after the webinar, and myself or Elisabeth, I'm sure, will be able to get back to you and provide an answer. This is being recorded and we will make it available, so if you do wish to watch it again, that will be possible. We will put it on our YouTube channel, and I'm sure Britton Time will make that available as well through their normal social media channels. So without further ado, I'll hand over to Elisabeth to give the presentation.
Lovely, thank you so much, Tom. Pleasure to be here and to be partnering with WTT and to be talking to all of you today about our wills, trusts, probate, and a few other bits and bobs we do for private clients in the practice. So, let's see if the slides are working for me. There we go, I think that's worked. So many law firms exist, and you might be wondering why we think we're any different from the hordes of firms you see out there. So we're a firm of London trained solicitors based down in Brighton, and we pride ourselves on offering concise, no-nonsense advice to our clients. We aim to spread the view that legal services should help those who need it, and to achieve that, we are all of these things. We're transparent. We sit down with each and every client and we offer an unlimited time during our fixed fee initial consultations so that we can fully grasp our clients' objectives and so we can lay out all options they have to resolve their case. We're reasonable. We don't hide any fees or encourage clients to use us by offering like a low initial quote and then charging clients through the nose once they're through the door. Our fee estimates are what we genuinely expect it will cost to see a matter through from start to finish. Any leftover funds are then returned at the end of the client's matter to our clients. We're upfront. We offer no nonsense advice, and we feel, we offer no nonsense advice that we feel is what the client needs to hear. This might not always be what the client wants to hear, though. We don't believe in trying to secure an outcome where clients have no chance of success, because it only wastes their time and money. We don't agree with clients or promise what we can't achieve. We help our clients to invest their time and money on legal issues where it can make the most impact for them. And we're honest. If we can't help, then we'll tell you that. We cannot help in each and every situation. either because we don't specialize in a particular area or because to use a solicitor would just be prohibitively expensive for our client. If this is the case, we will have no issue with telling clients exactly that. If a client can reasonably resolve a matter themselves, then we'll always ensure they walk away knowing what they need to do. So what is it exactly that we do? So on this slide, I would like to briefly set out the areas in which we practice. Sorry, the slide seems to have frozen there. Oh, there we go. Sorry about that. Firstly, we have our civil litigation practice. That basically means any dispute or court process other than that relating to a criminal offence. However, we also assist with criminal defence work, but not legal aid work. Family law covers issues including divorce, dissolution of civil partnerships, judicial separation. And then we also assist clients with child proceedings and financial settlements. We can also negotiate and draft pre- and post-nuptial agreements. Employment law is a big area for us, especially in light of the recent situation with COVID-19. Also landlord and tenant matters. This includes advice on leases, tenancy reviews, and often disputes arising out of this relationship. Our team here at Britton Time is actually growing, and we're taking on new talent over the next few weeks, which is really exciting. So if you have any questions and queries outside of these areas on this slide, then please do get in touch. We may still be able to help. Lastly, we're of course here today to speak to you about our private client offering, which covers lifetime estate planning, wills, trusts, and probate. So who am I, maybe you're asking? I'm not going to spend too long on this slide. You can see I've got a lovely picture there. But this is what you need to know. I'm an experienced private client lawyer. I trained in the City of London at a fantastic private client boutique firm. And actually moved to Brighton fairly recently in March, just before the lockdown. So I'm still exploring the city. But I've been part of the Britton Time family since March this year. So we like to look at estate planning as the circle of life. It all begins with good estate planning during an individual's lifetime. This process identifies everything you have, and we help you identify how to structure it. This process will include making a will that says how your estate should be distributed. It might include a trust to give additional powers to the executors in your will. Powers of attorney will ensure that if you lose capacity to make decisions for yourself, that those you can trust can look after you in that eventuality. And ultimately, probate. This distributes your estate to the next generation. All of these steps aid in making probate quicker, simpler, and smoother, which in turn saves your executors time and preserves the assets you leave behind for your beneficiaries. The circle will then restart again for the next generation, for your children or beneficiaries who go through the same process, starting with the estate planning, relating to the assets left to them, and so on through the circle again. And if any of these steps are performed poorly, it can mean a huge chunk of your estate goes astray, either to the taxman or to lawyers' fees in the event of a dispute arising during the probate process. And I mean, whilst that might be good for business, it's not the intention behind anyone's will. So what we want to do is help prevent these eventualities. Moving on to a little bit of depth in our first topic today on estate planning. Much of estate planning, it might be sensible to undertake for an individual, will depend on who the individual is, what the individual wants to achieve, and the assets in their estate. So this is the assessment we will go through when a client comes to us for estate planning advice. In terms of who the individual is, the primary consideration will be the individual's residence and their domicile. Different tax regimes and rules will apply to individuals who are resident in England and Wales, and those who are resident overseas and own assets situated in England and Wales. In terms of domicile, this is one of those elusive concepts in English law. And the best way to describe it is a person's home, in quotation marks, the country they're most connected with. Every person has a domicile. It's not legally possible to not have a domicile somewhere in the world. For many, this will be the country of their birth, but it's possible to move to another country permanently, thereby attaining a new domicile. This new domicile you attain when you move to a new country, that can be offset by a move to another new country or a move back to your home country, which revives the original domicile from the individual's birth. Secondly, we'll consider what the individual actually wants to achieve. They, for example, might want to transfer their house to their child. House is one of the largest assets in a person's estate. They might want to pass that on before they pass away, so before their will takes effect. Or an individual might want to liquidate their investment portfolio so they can make monetary gifts during their lifetime out of the proceeds. So both of these are examples of the aim to pass on assets to the next generation or to someone during a person's lifetime. But each of these scenarios will have many, many different aspects to be considered before any assets are transferred. Thirdly, we'll consider the individual's personal situation and their assets as a whole. It may be that there is another way to achieve the same goal, but in a more time, tax, and legal costs efficient way. As lawyers, we must look after our clients' best interests, and it's rarely in our clients' best interest to spend a huge amount of money on legal fees without much to show for it at the end. So it's always going to be an important consideration when we're discussing options with you. The main goal is to go through this process with our clients as few times as possible. So our team will always try to future-proof any planning we put in place. I mean, we're lawyers, we're not psychics. And so we can only provide advice on the current laws and HMRC guidance, but we do our best to anticipate changes in the law and will warn you of the potential for change in the future. We do this by staying as up to date as we can with any announcements and potential changes in policy. So for example, one I wanted to mention today was the UK government's recent announcement to review the CGT rules relating to individuals and small businesses. This was announced on Tuesday, the 14th of July. So this is the tax which actually many industry professionals anticipated would be used to increase revenue for HMRC to help pay for the cost of COVID-19. I think the bill is at about £190 billion so far, and is only set to increase, with the full cost anticipated at least to be closer to 300 billion. This review of the CGT rules and the eventual increase potentially in CGT rates could greatly affect lifetime planning, which is already in place. Many receipts are treated as gains rather than income because the capital gains tax rates are substantially lower than income tax rates. So this type of planning may fall by the wayside now. Just very, very briefly, capital gains tax is actually a tax on the gain an asset has made during the possession of a person. So it's a tax on the increase of value between acquisition and disposal. Of course, we don't actually know what the changes might be and any changes that might come from the review of capital gains tax. It could be a rise in the rates themselves. It could be cutting back on exemptions and allowances currently in place. So we'll be keeping a very close eye on the proposals that come out of the Office for Tax Simplification. Any changes are unlikely to come in the next 12 months, but it's also unlikely that just one change will be sufficient to pay for the substantial bill from COVID. So there may be further reviews and amendments to other taxes coming in the future. So this is the type of advice we'd hope to stay up to date with for our clients. So just to give a brief example of an estate planning, at the end of the day, we're all just playing the game of life. For those who don't know, it's a game about all stages of life, from going to school to retiring. Most people follow a fairly set way of life. We'll go through some, if not all of the stages of life. You might get married, have a child, maybe start your own business, have another child, buy a house, set aside a bit of money, invest in some stocks and shares or an investment portfolio. But in the end, if you haven't planned your estate, it can be a total mess, which is code for hugely tax inefficient. So the goal of our estate planning practice is to transform your estate from something that looks a bit like this into something that looks like this. If you're the type of person who has, say, lots of cash lying around and you're not sure what to do with this, First port of call, I would say, is to speak to a financial advisor. But I also encourage you to get in touch with us, as we can help advise on the legal and tax ramifications of any financial advice you receive, and help you plan during your lifetime, and then also in your will. For example, it could be sensible to allocate certain gifts to charity to offset your overall tax bill, or take advantage of reliefs, consolidating investments to increase the inheritance that your beneficiaries actually receive. There's also had a few questions recently from clients about taking out life insurance policies, especially if you have a property with a mortgage that may not be paid off after you pass away. This can help your beneficiaries with the initial costs prior to the grant of probate if you were to pass away. When it comes to businesses, businesses can adopt an alternative business structure to ensure it's as tax efficient as possible. It's also possible to start a family investment company. So these are companies which are designed to hold and build family investments and pass these on to the next generation. It's a very popular alternative to a trust, and all the facets of company law can be used to help with the structuring, such as different classes of shares with different voting rights, and also bespoke articles of association. A family investment company would also allow the individual who would have been the settlor of a trust, that is the original owner of the assets. I'll talk a little bit more about trusts later. So it allowed the settlor to have the opportunity to retain an interest or a benefit from the assets transferred to the company, which may actually not be possible using a trust structure. So, full disclosure, it's often inevitable that something will go to the taxman following estate planning or during the probate process. But proper planning can help ensure that more is preserved for the benefit of the next generation.
Elisabeth, we've got a couple of questions, probably
Great.
worth taking. We've got a question here. Is there a recommended age or a certain income level where people should start consider estate planning?
That's a great question. I'd say there's definitely no age limit when you should start at least thinking and discussing estate planning. I would recommend that anyone who has assets over and above what's called the inheritance tax nil rate band should look at their options. So very, very briefly, the nil rate band is a certain amount of assets, or a certain value of assets, I should say, in someone's estate, which is taxed at 0% after they pass away. That's currently £325,000. And there's an uplift on the value of someone's home. So it only applies to their house. It's called their residential nil rate band. So that uplift can bring it up to 500,000. I mean, of course, if you live anywhere close to London, you're going to be at that limit already, to be honest. But I would definitely recommend at least looking into options and looking into whether some efficiencies can be brought in there, because you're over that 0% band for inheritance tax.
And another question, aside from the nil rate band that you've already mentioned, is there any other reliefs on death that can reduce people's estates?
There are actually other lifetime reliefs for inheritance tax, which people can take advantage of. So during someone's lifetime, every tax year, so that's 5th of April round to the next year, you have £3,000 completely tax-free gift allowance. So I can make gifts out of my accounts of up to £3,000, which will have no effect whatsoever on their on my nil rate band after I pass. There are other inheritance tax exemptions to take advantage of post-death as well, definitely. So for example, there is the spouse exemption. So any gifts on death or during lifetime between spouses or civil partners are completely inheritance tax free. So those gifts can be made. So we do see it quite often when we're drafting wills for a couple. that we may put in place what's called mirror wills, where they leave everything to each other in the first instance, and only on the death of the second person of the couple would they pass on assets to the next generation. And that's great because the nil rate band is not touched by the first spouse who dies, and the uplift of their nil rate band is given to the second spouse. So if there's none of their nil rate band is used, then 100% goes to the second spouse. So including the residential nil rate band I mentioned earlier, you can get £1 million 0% inheritance tax. So there's some advantageous planning to be had there, definitely.
so definitely, you don't have to be a millionaire to start thinking about, you know, all of this. No. And the effects on your estate.
No, definitely not. It's very sensible, even if you just own a house, to start thinking about these things and start thinking about how you might want to leave your assets. I'll come on to a little bit more detail later when I talk about our wills practice in particular. But for example, if someone has children under the age of 18, you should always make sure you have a will in place. Because otherwise, if they don't, and they don't appoint legal guardians in their will, for example, then the court has to decide who will look after the child. So it's a bigger package than just the amount of money you have. It's also thinking about who your family are, what your assets are, and how we can make sure, you know, someone's life as a whole is provided for, if that makes sense.
Yeah, absolutely. That's all the questions we've got on estate plan at the moment. So I'll let you move on to the next slide.
Perfect. Thanks, Tom. So we're going to talk briefly about trusts. I already just mentioned a few moments ago one of the alternatives of putting a trust in place, namely the family investment companies. But I wanted to touch upon trusts as an option, at least, as it's still one of the first things people think of when discussing estate planning. Trust can be a very helpful and important aspect of estate planning, but there are a number of things to consider before we get into the legal nitty-gritty. Firstly, what on earth is a trust? You need 3 parties to create a trust. A settlor, who I mentioned earlier again, that person creates the trust, and it's their assets that make up the trust assets. The trustees, they become the legal owners of the assets in the trust, and they hold them for the benefit of the third party, which is the beneficiaries, and they benefit from the assets in the trust, even though they don't actually own those assets legally. The documents creating a trust have to clearly set out who these parties are and the rules which must be followed during the lifetime of the trust. There are several matters to be considered when creating a trust, not only deciding who the trustee should be, and maybe whether professional trustees should be involved in the administrative process. I mean, also individuals can handle the responsibilities on smaller scales. The nationality of the trust often also needs careful analysis, depending on the assets to be settled. We can only advise on trusts under English law, but English people can have trusts which are created and regulated by other legal systems. And these are available because there are preferential tax treatment for trusts overseas. Full disclosure, in England, there's actually a 20% inheritance tax charge on the value of assets at the moment they're transferred into the trust. There's also ongoing inheritance tax implications for English trusts, which can be quite a big deterrent for creating an English law trust. Another important issue is that the settlor, the person whose assets go into the trust, cannot actually or potentially even derive any benefit from the trust. Even if they're a potential beneficiary, the assets in the trust won't be removed from their estate for tax purposes. So if I were to put assets into a trust and in the documents, the beneficiaries of that trust are any member of the Squires family, I'm a potential beneficiary, and I won't have legally given away that property I've put into that trust. The main document in the creation of a trust is called a trust deed. This sets out who the parties are and the rules governing the trust, and it'll be signed by the settlor and the trustees. Each party will have a legal representative which negotiates the document on their behalf, aiming to get preferential terms for their client. This is about lifetime trusts, what I'm talking about here. We focus on, as a firm, we focus on when someone wants to create a trust through their will. Say if they wanted to pass on assets to someone who's under the age of 18, a short-term trust would need to be put in place for that person, so that the assets can be safeguarded until that person's 18 years old. We also see it with people wanting to put assets into trust for people who are, you know, not under 18, but maybe under the age of 25 or 30, if they know their beneficiaries need to do a little bit of growing up maybe before they get their assets. That's something we've dealt with in the past. So our focus is definitely will trusts rather than lifetime trusts. As a firm, we also specialise in disputes relating to trusts. So whilst the trust deed will set out the terms of the trustees' relationships to the beneficiaries, those trustees also have legal obligations over and above what the trust deed says in black and white. So there are numerous times when trustees may not fulfil their duties, or maybe where the beneficiaries accuse them of not doing their duty, or they might attempt to compel trustees to do something or to release certain information. One matter to note in a trust dispute situation is that the settlor falls away once the trust is in place. So the person who previously owned the assets has no rights anymore. It's only the beneficiaries of a trust who get the benefit that the trustees, you know, are working to generate. Only those beneficiaries can hold the trustees accountable for their actions, or indeed lack thereof sometimes. As a firm, we've dealt with many different trust-related disputes, including trustees failing in their duties to the beneficiaries, not fulfilling tax obligations or reporting obligations, and then also non-contentious applications to the court, which are needed to amend terms of the trust to give the trustees permission to take certain actions, for example. So we've done a breadth of work in this area. Lovely. We're going to move on to talk about wills now. So I'm a lawyer. Of course, I'm going to tell you to make a will. But I'm not going to tell you to do that so that I can just charge you fees for doing so. There are so many important reasons for someone to make a will. I mentioned one of these earlier, where you have a child under the age of 18, so that you can, in your will, you can appoint the legal guardians of that child rather than have the court doing so. Secondly, if you don't make a will, then certain set statutory rules will come into play. These are called the intestacy rules, and these dictate who inherits your assets. So those strict statutory rules have not been updated for quite a long time, and they don't really take account of 21st century relationships. For example, an unmarried cohabitee will not receive anything under the intestacy rules, whereas a spouse or civil partner will. The rules follow the bloodline, so children, siblings, and parents will benefit, but no friends or stepchildren can benefit under the intestacy rules, of course, unless the latter have been formally adopted. So adopted children will benefit, stepchildren won't. So if you decide to make a will, one of the really great things about England and Wales is that we have completely free reign over how to leave your estate. That's complete testamentary freedom. There are no forced heirship rules that cannot be offset by your will. So for example, in Europe, there are a lot of forced heirship rules that say that you must leave a certain amount of your estate to a spouse or a child. Here we can disinherit people. I mean, this is great, but humans aren't amazing at having all those choices. Think choosing what to watch on Netflix times 100. There's only one exception to this rule, where we have complete testamentary freedom. And that's when people who were dependent on you immediately before your death can challenge a will, which doesn't provide for them satisfactorily. So there are very, very strict rules around this, however, and such a challenge is not open to everyone. And there are very strict time limits for bringing a claim. it's not a guarantee as well, and it can only be granted by a court, that amendment to that will. So what can Britton Time offer over and above the quick, cheap services you see around these days? Firstly, will writers are not regulated to a set standard. Lawyers are. We also have a breadth of knowledge and will take other considerations into account when advising about the provisions in someone's will. And this will be far broader than will writers possibly could. So yes, it might be more expensive, but the phrase "you get what you pay for" is definitely true in this area of the law. Our service goes over and above many other services, and we carry out a review of your assets and provide inheritance tax advice as we go along and as we make wills. And this will ensure that the estate is as efficient as possible within the rules as they currently stand. So this process will also help to get you thinking about what assets you actually own, and will help ensure that all those assets are taken into consideration. So in doing so, we also help to aim you future-proof your plans and minimize the number of times you will need to amend your will. We'll help you to provide for every eventuality, because we do a lot of contentious probate work. We actually know how many challenges to wills come about, and we'll help you safeguard your estate and wishes against this possibility. Of course, no one really enjoys talking to their lawyers about their will and what will happen after they die, and we totally get that. So we try to make it as quick, easy, efficient, but also as thorough as possible. We can also act as an executor for your estate if you'd like us to, and provide safe storage for the will. So there's no obligation on these. As we'll discuss in a few moments, there's real value to having a solicitor help with the administration of your estate. And we'll only charge our legal fees for doing so, and will not take any personal or benefit for the firm from the estate, other than the work we carry out for you.
Just a couple of quick questions, Elisabeth, before we move on.
Cool. Yeah.
There's something that's, I see Netflix on the screen, and something draws me to, within a world where everything has a password, or we're holding even assets digitally, you know, cryptocurrencies and all of that sort of stuff. How does what you've already said is kind of a law that was written years ago before all of this kind of was envisaged? How does that accommodate this new world we're in?
That's a great question, definitely. So cryptocurrencies and crypto assets can be passed on in your will, just like any other asset. When it comes to the passwords, in relation to maybe the online services, so for example, Netflix, you might have an Amazon account and that kind of thing, iCloud passwords, that kind of thing. I would always encourage people to write down all of those passwords and keep them in a safe place in their home. Maybe not on the computer, if that's also password protected. I keep a printed version so that people can find it when going through papers and stuff at a later time. I mean, this is.
Should the will make reference to where that can be found? Would that be helpful?
So it would be helpful, definitely, to have a reference to it in the will. However, I would definitely discourage people to keep any confidential information in the will itself, and that's because once probate is granted in an estate, the will actually becomes a public document. So it's something that I can go online and I can, for £1.50, I can download someone's will if it was entered into probate in order to get the grant. So it's one of those things where you definitely want to keep these things written down, and you can even keep it with the will. So for example, if we were to draft a will for a client and they wanted us to keep a list of even just the types of assets that they have, or where their digital wallets for cryptocurrencies can be found, that's something that should definitely be kept in a safe place.
Digital assets themselves, though, can be passed on just as easy as
they can. Yes. So they can be passed on within the provisions of your will, just like any other asset, really. as I said, there are a number of security aspects into accessing cryptocurrencies. You know, you've got your digital wallets and you've got your pass keys and your PINs. Leaving as much detail as possible outside of the will is great. That they can be passed on as an asset in the exact same way as any other asset in your will. So you can either refer to it specifically and say, I would like to pass on all of my cryptocurrencies held in XYZ accounts or on XYZ platforms to this person. You know, it might be your spouse or a child or whoever. But you can also leave it as part of your residuary estate. So the way we draft wills is you have the specific gifts, whether they are gifts of assets or monetary gifts, they're set out first. And then you have kind of an everything else provision, a kind of catch-all provision, which is called your residuary estate, and that will catch everything. So that can be a fluctuating amount. You know, all of our assets are constantly going up and down as we buy things in the shops and then earn money. So you know, those assets fluctuate, and it can be caught by that catch-all provision, or it can be given as an asset specifically to someone. So in terms of the drafting of the will and the way we provide for them within the document, they're exactly the same as any other asset as they're treated legally. I should say there are some quite interesting debates still ongoing about how cryptocurrencies are taxed. So I would love to deal with a probate which holds some cryptocurrencies in it to to really enter into that dialogue with HMRC about how they propose to tax them. So
that sounds like some famous last words there, Elisabeth.
I'll let you know how I get on over the next few years.
We've got another question here. If I wanted to leave my estate to charity, how does that work?
So it depends if you want to leave your estate as a whole to charity or just a small amount. There's actually a really great inheritance tax provision which states that if you leave 10% or more of your estate to charity, you only pay 36% inheritance tax rather than 40% inheritance tax on any amount over and above your nil rate band. So you can leave your entire estate to charity if you want to, or you can leave a smaller amount. You can even have a provision in the will which says, I would like to leave 10% of my estate to charity, so that however much your estate is worth at the end, you know, you're getting that preferential 36% rate. So it really encourages gifts to charity. Of course, there's no tax during someone's lifetime on gifts to charity as well. So so yeah, it's a really good thing to do, and you can do it however you'd like to.
Brilliant. That's all the questions we've got at the moment.
Brilliant, thanks, Tom. Great, so we're going to be talking about powers of attorney now. So a power of attorney is a legal document, and this delegates an individual's power or ability to make certain decisions to another person. There are several different types of power of attorney, and it isn't always about a loss of capacity to make your own decisions. So a general or ordinary power of attorney can be made over someone's decision making as a whole, and it can mean that others can, for example, sign documents on their behalf, or it can also be tailored to be only relating to certain assets for a certain period of time. So, for example, if someone's going trekking in the Amazon rainforest for 6 months, they'll be off grid for that period. They can delegate certain decisions for that limited time period to an attorney. The second kind of power of attorney is what's called a lasting power of attorney. I think people have more heard of enduring powers of attorney. So lasting powers of attorney have replaced enduring powers of attorney. So you can only get a lasting power now. There are two kinds of lasting power of attorney. One relates to property and financial affairs, and the other relates to health and welfare. These are a little bit more geared towards making provision for the eventuality of someone losing capacity. I mean, of course, again, most people hate the idea of someone else being able to make these decisions for them. But the key to a power of attorney is they need to be made whilst the donor being the person delegating the power, whilst that person has capacity to decide who should be making decisions for them. If something were to happen, which means that a person loses capacity unexpectedly, then if there isn't a power of attorney in place, then the Court of Protection has to decide who can be a delegate for that donor. And it can be a really, really lengthy and expensive process going to the Court of Protection. Whereas having a power of attorney in place, this means that important decisions can be made without the delay and expense of going to the court. Of course, whilst we're all healthy and young and compos mentis, it's the last thing anyone wants to think about. I would emphasize the value of putting something in place, as these can be really, really helpful in the event of an incident occurring out of the blue, such as an injury or, God forbid, a coma, something like that.
There's a couple of questions just regarding power of attorney. What's there to stop the power of attorney going on a spending spree with their newfound access to the money?
So you can include what's called preferences and instructions in a lasting power of attorney. Preferences are requests to your attorney, sending out what you'd like them to do. Instructions are like directions, telling attorney what they can, cannot, shall not, must not do with your money. If they were to act outside of these kind of stricter instructions that you give them, then action can be taken against them through the courts for misappropriation of your assets. So that would be that's more of a civil procedure rather than theft. You'd probably go through to do misappropriation, and they'd have to pay the money back to your estate. So, and if they go outside of those powers, and they go over and above what you strictly kind of are okay with them doing, then they, action can be taken against them. I mean, this is true if they're not. Sorry.
So I was just going to say, can anyone be a power of attorney?
There are strict, no, there are certain rules against who cannot be a power of attorney. For example, trying to think off the top of my head, I know someone under 18 can't be a power of attorney, but there are fewer regulations than you'd think. So, for example, someone having, committed an offence in the past or something, that doesn't give them a black mark against being a power of attorney. So they can still be appointed under a lasting power of attorney. So a lasting power of attorney also has to be registered with the Office of the Public Guardian before it can be used. And within that process, there's an option to list people who are to be notified in the event that it's registered. So that's kind of an extra layer of protection. So if you appoint one of, say you've got 3 children and you appoint one of them under your power of attorney, you can put that your other 2 children should be notified when it's registered, which then means that the child who's the attorney can start making decisions for you. So there's sort of a third-party regulation, which is possible there.
Okay. And another question here. I don't think I'm going to suffer from dementia or Alzheimer's, but is it still worth making a power of attorney?
Yes, I mean, it's always worth making one. None of us think these things are going to happen, and I don't want to start making everyone paranoid or anything, of course, but the whole point of a power of attorney is to prepare for the unexpected. It's designed to help you or to help protect you really in these unexpected situations. We can lose capacity for so many different reasons, so there's a car accident or something, and you're in a coma suddenly. Your family wouldn't be able to do anything with your money or be able to make certain important decisions about medical care in that situation without a power of attorney being in place. It's one of those things where once you start thinking about it, you go, oh my goodness, I definitely need one, but so few people really think about it.
Yeah, no, I agree. Just sitting here myself, I'm thinking not something I have, but maybe something I should have. So yeah, absolutely really good
That's
points.
fine. Drop me a line after this, Tom.
Don't worry. That's all the questions we've got on power of attorney at the moment. So
fantastic. Great. Yeah, keep those questions coming. They're really good ones. Thanks, guys.
Oh, we just have one more here. Sorry, just before we move on. Do I need a power of attorney for my wife?
Yes, for your wife to make those kinds of decisions, you would need one, definitely.
So I guess the question is, it's being someone's spouse doesn't give you automatic rights, that the same rights that a power of attorney would give.
Exactly. Yeah, you're exactly right. No, it wouldn't give you the same rights. You'd need a power of attorney in place, even if that person would be what's kind of known as the loose concept of your next of kin. That isn't enough when it comes to dealing with assets on your behalf. You know, if you're a legal owner of something, and you know, your next of kin can't just say, oh, you know, he's in a coma over there, I'll go deal with those assets for you, don't worry. That's not going to hold up legally. You definitely still need a power of attorney in place.
Brilliant.
Great, thanks, Tom. Okie doke, we're going to start talking about probate. So probate is the kind of general term for the legal ability to deal with the assets of someone who has died. Whether that's extracting money from, say, their bank accounts or selling their house, you're rarely allowed to do any of it really without the grant of probate. I mean, I'm not going to sit here and pretend that every estate needs a lawyer involved. You don't need a lawyer to get probate in every situation. Some are very, very straightforward and can be very, very properly dealt with by individuals with little or indeed no input from lawyers. However, there are some more complex or larger estates that do need input from a lawyer. If you're at all unsure about the process, Britton Time can be as involved as you want us to be. So I've got one on the go at the moment where I prepare every single document. I fill in the forms to instruct the shareholding registrars to sell the shares, and all I do is send it to the executors ready for checking in their signature. But then we can give that level of service all the way down to just giving a small or discreet piece of advice about how one particular asset in the estate should be reported to HMRC. As a firm, we can provide the end-to-end service, even from the registration of the death up to final distribution of assets. In that situation, using a firm such as ours, you can be safe in the knowledge that the capability and expertise are there for you to call upon if you want it. But there's never any obligation to do so. So the probate process on paper can look like a very, very straightforward form filling exercise. It's report the estate to HMRC, send everything off to the probate registry, get probate. Should be very straightforward, and many estates are like that. However, there are very often unexpected complications during the process. This can be from something as simple as someone's name being spelled incorrectly in the will, to even the discovery of another family after the death of the patriarch. We have seen it all, unfortunately. This slide demonstrates some of the examples of things that can make probate a little bit more complicated. So that includes children from different marriages or different divorces, overseas property, business assets, slightly more complex inheritance tax returns. We can even do something as simple as just double checking inheritance tax returns before they go off, because it's always worth getting it right first time, and not having to enter into that dialogue with HMRC. And then diverse investment portfolios and poor estate planning can really up the complexity of the probate process. I'm going to move on to talk about contentious probate, unless you've got some questions for me, Tom.
There is a couple of questions. There's a question here. What happens to my debts if I pass away? Do my beneficiaries inherit them?
So your beneficiaries won't inherit the debts, but your estate will have to be settled before the beneficiaries get the benefit from your assets. So what that means is that your executors, who are appointed under your will, have to deal with all of your debts. So that will the beneficiaries won't become personally liable for debts, but yeah, debts will be paid out of the funds in a person's estate prior to distribution of assets. So I mean, of course, that's kind of looking at the negative, like if I owe debts. Similarly, if you've you know, lent someone money, or you've lent an institution money, and you're owed money after you die, that debt is owed to you, and that must be recovered before assets are distributed. So your executors in your will fully investigate any money that's owed by you or to you, to ensure that, you know, all the books are balanced, as it were.
Real. And another question here, how do I minimise the chance of my beneficiaries arguing about who gets what?
I mean, we'll talk about that a little bit more detail in a second in the contentious probate, but the first step is going to be making a will. Speaking to a firm like Britton Time is good if you're worried about beneficiaries arguing or potentially a challenge to your estate. So we advise on contentious probate, which I'll cover in a second, and so we advise on the types of challenges that can be made to a will, and we've helped challenge wills before. So we can help during the will writing process to make sure that the estate is as bulletproof as possible, basically, in order to minimize that chance of a challenge or an argument, and ensure that, you know, all the assets are preserved to accord with someone's wishes.
Brilliant.
Right, thanks, Tom. All right, contentious probate. So this is the juicy stuff. The term contentious probate, this refers to any dispute about how a person's estate is administered following their death. So we've talked about this a little bit already, which is great. But I mentioned earlier the ability for certain dependents to make a claim against an estate where they consider that they've not been sufficiently provided for under the terms of someone's will. This is covered in the Inheritance Provision for Family and Dependents Act 1975. But this is just one of many causes of action, really. Other causes of action include sorry, excuse me, challenging the authenticity of a will, i.e. saying that a will is fraudulent. It can be alleging undue influence over a testator at the time of making their will. So that means that the testator, their wishes as written in the will were kind of distorted by a third party. Usually that third party is the main beneficiary under that will. The testator may have been lacking capacity at the time of signing the will, or they may lack the knowledge and approval of the will. So that last one means that they don't really understand that they're making a will in the first place, and they don't really have an understanding of what it means to be passing on certain assets to certain people. It can be quite a difficult process to go through this. So sometimes there are also more simple matters, such as questions over the interpretation of a certain clause in the will, challenging the decision of an executor, or as we mentioned a second ago, disagreements between beneficiaries or indeed former beneficiaries, where the will has changed without all of the beneficiaries being informed. Of course, there are advantages and disadvantages to any process such as this. Advantages would be that it's a court-approved decision. The parties can only appeal through the very, very strict legal appeals process, rather than there being just a really long, protracted argument between family members. Also, clients usually start proceedings of these types through a desire for a sense of justice, and the litigation process is sort of a stamp of approval. It's a way of getting justice if you really feel that that's needed. An agreement is rare in certain situations as well. So an independent voice through the litigation process can be really effective in deciding matters. However, there can be some very, very serious disadvantages, one of which is costs. Litigation is a very, very expensive process, and it can often lead to the depletion of the estate assets. We'll never advise someone to start a litigation process where it will eat up the entire estate. It's just not worth it. It would always be worth negotiating in those situations. Contentious probate is also an extremely emotional process. It's often more a matter of principle than anything else. So during the grieving process is often actually the worst time to begin making these important decisions, like entering litigation. Emotions will be running high, it can cloud anyone's judgment. So as a firm, we try to be objective and be the voice of reason to help logic be at least a factor in this decision-making process. It's also really, really hard to prove anything. So I mentioned the causes of action earlier. The type of evidence needed to prove some of these challenges can be a real massive barrier to these types of cases. And it's also a lot more complicated to bring these kinds of proceedings to an end. It's not the same as in a civil litigation process. So it's not as simple as kind of just making an agreement and sending that to the court to be stamped. So as you can see, often our advice will be at least to try to negotiate before bringing any kind of proceedings. A negotiation, especially soon after someone's death, is most usually effective because what's called a deed of variation can be put in place. If it's signed by all the beneficiaries of a will, a deed of variation can be put in place within 2 years of someone dying. So that if that can be settled and agreed upon, that will be our course of conduct. It's obviously not always the case, and we've seen many contentious probate processes through. But yeah, it's a very interesting area of law. And that was all I had to say. Is there any further questions, Tom?
Yes, we do. We've got some questions lined up here.
Right.
Can I sell a house as a beneficiary before probate is granted?
So it depends. As you'll learn, a lawyer's answer is always it depends, really. So it is possible if someone is appointed as an executor in a will rather than an administrator. So an administrator is when there's no will in place. But an executor, their power to deal with the estate assets actually comes from the will itself. So legally, it is possible to sell a house if you haven't got probate yet, as long as you're an executor, and as long as you have the will showing that that you have that power. It is unfortunately fairly rare for that actually to happen, because if you're trying to sell the house, of course there's a person on the other side, there's a purchaser there, and very few purchasers, especially if they already have legal representation, will agree to that. Going through. A lot of the time, lawyers will at least advise their clients to go, no, you've got to wait for the grant before you sign anything. But it is also risky to the executors to do that, because if they start selling assets and there's a challenge to them for doing that, they can be personally liable for the value of those assets if they've already distributed the estate. So it's risky, and I would caution highly against it, but it's not impossible.
Brill. Final question here. What will happen to my will if I get divorced?
Oh, that's an interesting one. So there are certain life events which will automatically revoke your will. Getting married is one of them, unless you put a clause in the will which says it's in contemplation of the marriage. Divorce is a bit of a funny one because the divorce itself doesn't revoke the will, but the ex-spouse, after the decree absolute has come through, is basically treated as if they died on the date of the decree absolute being issued by the court. I mean, that might be fine for some, like after the decree absolutes come through, but if we know a divorce process is ongoing, they can take a very long time to go through, and you often have kind of ancillary child and financial proceedings. So it might be sensible to actually make a new will, or even just put what's called a codicil in place, which can amend a will without replacing it. It might be useful to put that in place to remove mention of the spouse you're in the process of divorcing. prior to the divorce being finalised. But yeah, that's an interesting kind of quirk in this area of law.
So effectively, a marriage tears up the will, and effectively intestacy applies at that point.
Exactly.
The difference being divorce just reads the will as if the divorcee is no longer alive, but
exactly.
all other of the will still apply.
Yeah, exactly.
Well, great stuff.
Yeah.
That's all the questions we've got. So unless there's any other questions coming in, which there isn't, we'll wrap it up. I would just like to say thank you first and foremost to Elisabeth for joining us. I know she's particularly busy at the moment, so thank you for giving up an hour of your time. It's much appreciated.
Of course, thank you so much for having us. It was an absolute pleasure.
Thank you all for everyone who's joined us. As I said at the start, this has been recorded. It will be placed up on the WTT YouTube channel, and it will also be made available through Britton Time's usual social media channels, of which some of them are on the screen here. Facebook, Facebook,
LinkedIn.
Twitter, LinkedIn, and the one I don't use at the bottom,
Instagram. We've got a very shiny new Instagram page, which our digital marketing genius Dominic is taking the lead on. It's a great page, so follow us if you fancy it.
Email addresses is there, telephone numbers is there. You can contact WTT on www. Oh, here we go. We have got a page here. info@wttconsulting.co.uk, or website is www.wttconsulting.co.uk, where you'll find details of all the services that we offer. Thank you very much, and hope to speak to you all soon.
Thank you.